Okay, good afternoon, everybody. It is 2:01. Thank you for joining us today. I am Teresa Hatton. I am the CEO of the Massachusetts Association of Realtors, and I'm excited to introduce our legal and advocacy attorneys that help support all of our efforts throughout this past year and in the future. So if we can go ahead to the next slide, I will introduce our team. First is Justin Davidson, who's our General Counsel and Director of Government Affairs. Catherine Taylor, who is our Director of Education and our Associate Counsel. Kate Berard, who is our Director of Professional Standards and our Associate Counsel. And Johnny Schreiber, who is our Legislative and Regulatory Counsel. And with that, I'd like to pass it over to Justin. Each member of the team is going to take a certain subject matter and then pass it on to another member of the team. So Justin, please kick us off.
All right. Thank you, Teresa. We're going to kick it off with one of the bigger pieces of news from this year, and that's a litigation update. You see here in front of you a lot of cases filed over the past few years, with one of them coming to a verdict this year. So I want to spend just a few minutes now and kind of review what's happening on the litigation front, and also let you know that if you want to hear more about this, because this is not a subject that we can cover in 10 to 15 minutes, we're happy to come out to your office, meet with your agents. We can do that in person, we can do that remotely, and really dive into the details of the litigation, what that might mean moving forward, and answer any questions that your agents have. So with that, as I said, here's a list of the cases. The ones that we want to pay particular attention to are the Burnett, also Sitzer case out of Missouri, and the Noselec versus MLS PIN. That is the Massachusetts case that you may have heard about. And then you see the other ones. We've seen some copycat cases pop up. They all have the 2023 filing year. We expect to see a few more grow there. And then there are also a couple of cases at this point that approach the same subject, but from the buyer perspective. So an indirect purchaser argument will be made there. So what are the seller cases about? The issue really boils down to the cooperative compensation rule. And that's the rule for realtor-affiliated MLSs that requires a participant to make an offer of compensation to a buyer broker in order to have their listing in that MLS. Now, historically, that could have been something as low as $1. NAR has clarified that 0 is an offer of compensation. So, what changes could be coming might be big, but they might not, because that offer of compensation has always had an could have been something as small as $1. Now, the allegation with that issue is that there's a price fixing scheme, and it's not a price fixing scheme like we all generally think about, where broker A and broker B get together and decide that we're all going to set the same compensation rates. What they're arguing is that the conspiracy exists because there's evidence to show that it does. So it's not sort of that explicit antitrust violation that we've talked about so much in the past, but the allegation is that the price fixing scheme exists because there's evidence to show the consistency in the compensation rates. I mentioned the big one, Burnett Sitzer versus NAR and a couple of corporate defendants. That one is the one that did just go to trial this fall after a couple of weeks of trial. The jury deliberated for just under 2.5 hours and did find in favor of the plaintiffs, finding that NAR and the corporate defendants were liable for the conspiracy. Now, NAR, of course, stands by their assertion that there was no evidence of a conspiracy, and NAR put on a very strong case, provided great witnesses to provide the evidence to show that there was no conspiracy. However, the jury in Missouri did find for the plaintiffs. So what does that mean for next steps? First thing to understand is this is not final, and there's still a lot of time before anything will become final. NAR has indicated that it is their intention to appeal this verdict. mostly because of the errors that happened at trial. There was evidence that was let in where there were agreements not to let certain evidence in. But before the NAR even gets to an appeal, there are some post-trial motions that need to be resolved. That looks like it'll take us into about April of 2024 before those post-trial motions are resolved, and then NAR will be able to look towards an appeal. So still a lot of time for this one to work itself out. So giving you that timeline just so you understand what's happening. As always, NAR will continue to update the membership as they move forward, and we'll talk about some resources in a little bit on that. Now in Massachusetts, there always has to be a Massachusetts connection, and unfortunately in this one, that is the case as well. It's in the No Select versus MLS PIN case, and this was filed just about this time in 2020. And then over the summer, MLS PIN agreed to a settlement with the plaintiffs. So that was entered with the courts June 30th over the summer. Now what happens here is the plaintiffs and the defendants can enter into agree to a settlement. That needs to be filed with the court. The court still needs to sign off on that settlement. And the way the timeline worked out originally, we were looking at that settlement being likely approved by the court and implemented right in the first week of January, right around January 7th of 2024. However, in late September, the U.S. Department of Justice stepped in and filed a statement of interest in the case with the court, asking for an additional 2 months to review proposed rule changes that are included in the settlement. We're going to talk about those in just a minute. So what that now means is that the final settlement deadline moves to March 7th of 2024. So we won't likely see any implementation of that settlement until that date. Still an opportunity for that to be delayed even more, but that's the date that we're looking at right now. Important to note that NAR, MAR, no local associations are part of this lawsuit. So the information we're providing you today is information that we have based on what has been filed with the courts. We're not counsel for MLS PIN or the plaintiffs, obviously, but part of that settlement does include some rule changes for MLS PIN. And here they are in a nutshell. Most notably, MLS PIN will remove the requirement that an offer of compensation must be made to the buyer broker. In order to enter a listing into MLS PIN, the listing broker is going to have to provide notice to the seller that an offer of compensation to the buyer broker is not required, and that if one is made, that offer of compensation is now going to come from the seller to the buyer broker, no longer from the listing broker to the buyer broker. So that's one of the key changes. It is also the intention that that offer will likely become negotiable throughout the term of the contract. So MLS PIN has used counter offer being made by the buyer, traditionally what we think of as an offer. If that doesn't align in every way with what the seller is looking for, then that commission term is negotiable like any other term of the contract. So something to keep in mind. I say keep in mind, this might all change. So this is where we are today. As I said, we're happy to update this. We're going to be updating you as this moves forward. So those are the big changes in the rules that MLS PIN and the plaintiffs have proposed to the court. And then the final piece of the settlement is a payment from MLS PIN to the settlement fund of $3 million. What does that mean for members of MAR? It means to be on the lookout for changes to our forms, new forms and revised forms. I know Catherine's going to dive into this a bit more in a few minutes, so I'm not going to spend much time here, but we will have to make some changes to our existing forms, so be on the lookout for that. And as I've mentioned now, education, outreach, training, we are here for you to help you work with your agents to make sure they're prepared for any changes that are coming in the future. Now, the easiest way to be prepared for any changes that may be on the horizon are to use buyer representation agreements. I would encourage all of you to consider a policy in your office to require that your agents are using buyer representation agreements. They help you. They will recognize and memorialize that exclusive relationship with the client. It's also going to provide your agents an opportunity to detail the services, costs, and expectations throughout the transaction. And that allows them to explain how fees will flow in a transaction. So really an important tool to protect you, as I've said. An existing offer of compensation right now could be $1 or $0 in some MLSs. So make sure you have a representation agreement in place with each buyer that talks about, if that is the case, how is it going to be handled, so that you are not coming to the table at the last minute trying to figure out how it is that your commission will flow. So that's why, when should they be used? Always. So consider that. And then I do want to talk about how we can all work to help you prepare your agents for changes. And I think number one is get comfortable with your value statement, why it's important to work with you as a particular agent, and importantly, why it's good to work with a realtor specifically. Get agents comfortable with using the buyer agency agreement. We understand that there is some hesitancy to it. It can be difficult to walk a client through, but if you start now, you'll get more and more comfortable with it as time goes on. As you work with sellers moving forward, make sure you're thoroughly explaining the listing agreement and how that compensation and business relationship is going to work, particularly when it comes to compensation, how that's going to flow. So if a seller is going to offer compensation to a buyer broker, or a listing broker is going to offer compensation to a buyer broker, that the seller understands how it is that money is going to move. And be clear that the commission is negotiable. And on that, I'll just say, you don't want to be walking in with pre-filled out listing agreements where the commission, and particularly a co-broke, is pre-filled. Have that discussion with the seller and have them be part of that decision. So finally, just to wrap up, I mentioned that NAR does have resources available, two that we want to flag here. The first being competition.realtor. That's a great site to keep you updated on everything that is happening with the lawsuits across the country. And then also realestatecommissionfacts.com. This one more geared toward helping consumers understand how broker services work and how real estate commissions work. So with that, I'm going to say it once again, we are here for you. If you'd like us to come out to your office or join you remotely, happy to do so, and we can spend a considerable more time talking these issues over. So with that introduction to the issue, now I'm going to turn it over to Catherine Taylor, our Director of Education and Associate Counsel, to talk about our legal hotline and MAR forms.
Great. Thanks, Justin. And thank you, everybody, for joining us today. Wanted to touch on the MAR legal hotline, which is one of the greatest member benefits that I think that we offer to our membership. We are available for all of our members now. It's no longer limited to those authorized brokers and agents within their office. Anybody who's an MAR member can call. We're here Monday through Friday, 9 a.m. to 4 p.m. You can either call us or you can email us. We will do our very best to get back to you. If we miss your call, and at the very least, we will return your call within the same business day. Since we have opened the hotline to all of our members, we have had a significant increase in usage, which is wonderful. We have received almost 2,000 questions so far this year, and that's from almost 1,000 individual users. So we are thrilled to see that our members are taking advantage of this member benefit. What you'll see on the screen are the 15 most common topics that we have received questions in. Certainly there are a number of other topics we received questions in, but I didn't want to clutter the screen too much for everybody. As you can see, questions related to rentals blow every other topic out of the water. This has been the second year running that questions related to rentals have far surpassed other questions, and I think it's largely due to the market climate, the climate in the marketplace. with the inventory shortage, a lot more agents are turning to rental business and they have questions about it. So that has been an interesting process to watch. We also have received, as you can imagine, a number of questions related to compensation and commission. Now, a lot of times that's going to come into play with regard to questions related to the litigation that's happening both here in Massachusetts and nationally, but also there are always questions that pop up related to procuring cause and things of that nature. Disclosure and agency are close behind. We always receive a lot of questions on those. Fair housing and advertising. Within fair housing, we do receive a lot of questions on emotional support animals. And then you'll see the numbers sort of trickle down going on from there. But we're going to cover a couple of the most common questions that we've received on the hotline this year. And these are just sort of general questions that tend to come up from time to time over and over again in some version or another. One of the primary questions we get is, how do I legally screen a prospective tenant? And I'm glad that people are asking this question because it is an area that if you do engage in it improperly, you could find yourself in a lot of hot water. So good rule of thumb is to make sure that you are applying the same criteria to all prospective tenants and being wary of policies that could have a potential disparate impact on protected classes, such as a blanket criminal history policy. We also get a lot of questions related to what fees can be legally charged to a tenant. And of course, we have our security deposit statute that lays out very strictly that at or prior to the commencement of a tenancy, only 4 things can be charged to a tenant. That's going to be your security deposit, your first month's rent, your last month's rent, and the fee to change the lock and key. Anything that falls outside of that, such as an application fee, an amenity fee, a parking fee, a pet fee, anything like that could be considered an illegal fee. How do I deny a request for an assistance animal? This is a question that we get in a number of different formats. And the best advice we can give you when you're faced with this question, if you're a realtor, you're not an attorney, and you don't want to be providing legal advice to your client as far as analyzing that request for them. Direct them to work with an attorney, particularly if they're looking to deny that request for an assistance animal. The landlord is required to go through a interactive process with that tenant to determine if it's reasonable. And certainly that can be a complex analysis that should be done with the assistance of an attorney. Lots of questions about how teams can operate and how they can advertise. Massachusetts doesn't have a specific statutory or regulatory framework for teams. So we have to work within the existing licensing construct that we have. So essentially you should look at a team and apply the rules as they would be applied to an individual salesperson. If you have specific questions about that, I would definitely direct you to look at the FAQ that was put out by the Board of Registration on teams. Covers everything you could possibly want to know about teams, particularly related to advertising and team names. Another question we've been getting a lot of recently is whether a seller has to formally reject an offer. Certainly they have the opportunity to do so. It does provide that option on the contract to purchase, but it is not legally required. When you submit an offer, it is valid for a certain time frame, whatever the buyer elects to have that offer open for. Once that time frame has lapsed, that acts as a rejection of the offer, so the seller doesn't have to take an affirmative action. Now, if they want to, they can, but there's no requirement and it can't be forced. If your buyer is concerned that perhaps their offer wasn't presented, there is the opportunity for realtors under the Code of Ethics to submit a written request to the listing agent for confirmation that the offer was in fact presented to the seller, or that the seller waived the obligation to have that offer presented to them. So it's not a rejection, but it does give you a little bit more peace of mind in that instance. Another big question we get is relative to how to cancel a listing agreement or how to cancel a contract in general. And I think one of the beauties of a contract is that it's hard to cancel, right? If you enter into a mutual contract, bilateral contract, generally it's going to take mutual agreement to terminate that contract prior to its expiration. That can be negotiated. Again, this is an instance where legal counsel is definitely recommended to help you navigate this process and negotiate that exit from the contract. And of course, who can be paid a referral fee? This is a question that comes up time and time again. And here in Massachusetts, we've got a couple of different very specific licensing categories. We have active, inactive, and expired. If somebody is active as a salesperson, in order to receive any real estate related compensation, they have to be affiliated with a broker. And then that compensation flows to them through that broker. So any referral fee would have to come through their broker. If they are a salesperson that is inactive, the only business they can engage in is referral business, and they can receive that payment directly. If they're expired, they're basically not licensed, right? So they cannot receive a referral fee. If you're unlicensed, no referral fee. And then of course, if you're a broker, regardless of whether you're active or inactive, you can always receive a referral fee directly. The caveat here, I always like to put an asterisk on this one, is with regard to attorneys. There's a large misunderstanding out there that attorneys are automatically brokers and can receive referral fees. That is not the case. Attorneys must also have a separate valid real estate broker's license in order to receive a referral fee. So, from a lot of the questions that we receive through the legal hotline, it gives us a lot of information about what issues our members are encountering in the field, and that can help guide us with regard to our forms library. Are there forms that need to be updated? Are there forms that need to be added? Are there forms that could be potentially retired from our library? So on the next slide, I'll review what updates we've made to our forms library so far this year. We've been very busy, as you can see, and we still have one more forms committee meeting remaining this year. So there could potentially be additional changes coming your way. We've added 5 new forms to the library so far this year. The first is a condominium addendum. So this is an addendum that you can attach to your purchase contract that provides that the buyer will be provided certain condominium documents and a period to review those prior to moving forward to the purchase and sale agreement. The next is a tenant representation agreement, and this is similar to your representation agreements that you're going to be using with your buyers and sellers. We just now have one available for those tenant relationships. We've also developed a confidentiality agreement. It is a mutual confidentiality agreement, so both the seller and the buyer are mutually agreeing to keep the other's information confidential during the transaction. Note that this form should be agreed to by all parties prior to submitting an offer, because otherwise it would not be binding on anything submitted prior to entering into that confidentiality agreement. We've also created a nitrogen sensitive area disclosure. And while this is primarily an issue affecting residents on Cape Cod, the way the Title V regulations were amended, it could impact other regions going forward. So keep an eye on that. And finally, we have the seller agreement to compensate cooperating broker addendum. It's a mouthful, but it essentially solves that issue that many people have been encountering with how to request compensation as part of the offer process without violating the code of ethics. So now we have a form that's available for you to use to allow the offer to be conditioned on the seller agreeing to compensate that cooperating broker. We also have a couple forms that we've updated. They were existing forms, and we've just made some changes to them. The concrete advisory and disclosure was previously one form for both buyers and sellers. That's now been separated out into two forms, one for buyers and one for sellers. We also updated our extension of time of representation. So previously we had different extension of time forms for each type of representation. Now they all appear on one form, and you can simply select what agreement you are seeking to extend. Finally, we have updated our exclusive right to sell listing agreement. The paragraph relative to broker compensation has been updated to now allow either the entry of a specific dollar amount or a percentage for that compensation amount. So it gives you a little bit more flexibility when you're working with your clients and discussing that compensation to put in what works best for you. And last but not least, our short-term rental 14-day exemption form is back by popular request. So that is now once again available in our library for your use. And with that, I am going to hand it over to Johnny to talk about our legislative updates.
Thanks, Catherine. So yeah, advocacy is another thing that your membership entails. And so we're going to start off with a little Schoolhouse Rock review of the 3 branches of government. Can you please go back? Thank you. So we are involved in all 3 branches. I think what people think of most when they think of advocacy is lobbying the legislature, which is absolutely something that we do. And the legislature makes laws, so that makes a lot of sense because they're making laws, they're changing laws, things that impact your business. However, we also advocate before the executive. The executive branch executes the laws, enforces them, and they have the regulatory structures. So we're often involved in helping to draft or advise on regulations. And we're also increasingly involved with the judiciary. The judiciary interprets the laws. And as you'll see later in my presentation, we've really stepped up doing amicus briefs, so friend of the court briefs. So the court is now accustomed to hearing from us, is getting better educated on real estate issues. And we have this sort of relationship that we're building with them, much like we have in longstanding form with the legislature and the executive. Next slide, please. So starting off, we'll put our best foot forward. We're really proud that tax relief is something that was accomplished in Massachusetts this year. It's something that has not happened in Massachusetts within the last 20 years, and many of the items that are listed here haven't been touched in even longer than that. I'm going to highlight just a few of them. There were even more items in the bill. These are the ones that we felt like were most relevant to overall Massachusetts competitiveness, as well as obviously real estate writ large. Something that's a bit of a new program, the Good Landlord Tax Credit, that allows municipalities to forego charging property taxes up to 100% of property taxes for naturally occurring affordable housing, so below market rents. So if you work with anyone that's providing that in the marketplace, it's something that they might be able to take advantage of. There's also a doubling of tax credits for lead paint abatement, as well as septic system repair and replacement, 2 things that are way outdated and were hindering those programs from being effective. We hope that this increase will help. And finally, I wanted to highlight the HDIP backlog. That stands for the Housing Development Incentive Program. It helps incentivize the creation of market rate housing in gateway cities. That program was so effective at creating housing that there was a huge backlog of projects. And so this tax relief bill provides $57 million to fund that backlog of projects, and to prevent a backlog going forward, triples the annual cap from $10 million to $30 million. Next slide, please. So moving into sort of the day-to-day issues that we've been dealing with, and some of the headlines, you've probably heard a lot about rent control, especially over the last several months. So what is rent control? I have on here, everything old is new again. You may have heard it as rent control. You may have heard it as rent stabilization, which I'm here to tell you is rent control. So that simplifies that. But rent control programs, at least from the past, typically just sort of had a cap on how much you could increase rents by. And then there was a board that you could go before if you wanted to make other changes. The sort of new age rent stabilization style programs still have a cap on rents, which is why I say they are still a form of rent control. Typically, we see them drawn as the consumer price index plus a certain percentage that you're able to increase rents by with a cap. And there's other pieces that are sort of levers being pulled in or out, but at the end of the day, they're still government regulation of rents. So why should you care? Well, as Catherine just mentioned, it seems like rentals are an increasing part of a lot of folks' portfolio of business. So, but even if you don't work in rentals, this is something you should be concerned about. So the proponents of rent control, as was seen very clearly in the ballot question that was proposed for the 2024 election, they want to regulate more than rent. And specifically, the ballot question that was submitted would have regulated brokers' fees. So very direct impact to the industry. It would have also regulated a lot of other things, including condoization, the removal of rental units from the market. This also will have a really negative impact on the market writ large, because rent control programs throughout history have been studied a lot, and basically in every single economic study, they have found that rent control decreases rental housing. So in the short term, it results in people pulling their units from the market out of concerns for what the future of rent control holds, people selling their buildings, people condoizing their units. That's in the short term. In the long term, more units end up falling out of the housing market due to disrepair, because it's harder to make any profits. And then in the even longer term, the construction of multifamily properties significantly slows or stops, because there's less ability for developers to make back the money that they would have to invest in building it. So not only are you losing units from the sort of depreciation that happens, but then you're also not building more units. So you have far fewer units on the board. So that's a huge problem, especially in Massachusetts, where our housing stock is already so far behind what is needed. So what's the latest development? I mentioned the 2024 ballot question. There's a long process to get on the ballot, and that starts in the year before you actually want to get on the ballot, which is why over the last several months, there was a lot of talk about a rent control ballot question. One was filed in Massachusetts. It went through kind of the first stages of making its way to the ballot and ultimately fell short. There was a deadline about a week ago at this point where proponents needed to provide 75,000 signatures to the state to then kick into sort of the next step in the process, and they fell far short of that. So that means there will not be a rent control ballot question on your 2024 election ballots. There is still legislation before the State House. We're at the end of the first of a 2-year legislative cycle. So there will be legislation that gets talked about now and through the future, but especially as we near the end of session in 2024. So we are opposing that, and I think we're in a very good spot with that. And we anticipate that there will be a new ballot question for the 2026 election, which means that you should keep your eyes and ears open for news on that question being filed in 2025. And what we suspect is that the proponents will have learned lessons from 2024, and that they'll come back with a better drafted question, more funding, and better organization. And I think that we've learned some lessons as well. And so we're already preparing for that potential question coming in for the 2026 ballot. Next slide. Transfer taxes. Probably heard about this one as well. The proponents call them a fee, but they are a tax. They essentially are a certain percentage that you have to pay when you sell your home. They vary in sort of how they operate, and there's a lot of different proposals out there. Some say they're paid by the seller, some say they're paid by the buyer. You know as well as I that the market will really dictate what happens there. We care because at the end of the day, they increase the cost of housing, which is a huge problem for people trying to buy housing. Even transfer taxes that have a baseline threshold for the cost of the home. One of the bill that got the most headlines had $1 million carve out. That still increases the cost of housing. In a lot of areas in Massachusetts, $1 million is close to the median value of homes. It also puts immense pressure on homes priced just below that threshold. Also, these policies are exclusionary. They would be adopted by different municipalities, and the ones that have expressed most interest are ones where housing prices are already very, very high and that basically develop almost no housing. So they're places that are already very hard to get into, and this will increase the entry cost. They're also unfair. They hit only about the 2 to 2.5% of folks who are buying or selling home every year. So a very small proportion of the population, and they're ultimately a very poor source of funding because they're highly dependent on the market. So what's the latest? There's more than a dozen bills that have been filed. There are some that would just allow transfer taxes across the state or in any municipality that wants it. There's some that are municipalities specific, where municipalities are just asking the State House to approve their own transfer tax proposal for their own town. Most notably, the Healy administration and her housing secretariat proposed a housing bond bill. It has a lot of funding for housing and also has several policy sections. And one of those was enabling cities and towns to implement a transfer tax if they wanted one. We strongly oppose transfer taxes, and we have some other solutions that we recommend and have been talking with the legislature about. One is using the Community Preservation Act funding, which allows municipalities to vote to put a 3% surcharge on property taxes, or up to a 3% surcharge on property taxes, to unlock state matching funds. And that money can go towards affordable housing as well as other improvements in the town. And one of the biggest things we hit on as well is zoning reform. As I mentioned, a lot of the towns that are seeking this funding make it very, very hard and very, very expensive to build housing because they have very large minimum lot sizes. They mostly ban multifamily housing, and so it's exorbitantly expensive to live there. So our point is that there's better solutions than taxing housing, and that is to use other funds and to decrease the cost to create housing, thereby unlocking more affordable housing. Next slide. I mentioned at the start that we're involved in advocacy beyond the legislature and the executive, and that would be in the judiciary. These are 4 cases listed on this slide that we were involved with over the course of the last year, and I'm going to do just a brief run through of them. Obviously, as Justin mentioned, we're always happy to speak with you, your offices, answer questions, obviously about this or anything else I spoke about. Feel free to reach out anytime. So in the Wang v. Ma case is a case about buyer agency agreements, something that we've talked about in this presentation earlier. There was a buyer agency agreement used in that case, and the question before the court was, because the buyers breached that agency agreement, could the buyer's agent recover their commission? And the court sort of had these questions of not really understanding how real estate worked, and they were confused about what happens because there was a breach. So the buyer's agent couldn't have possibly performed. So why should they get their agreement? There was suggestion at lower decisions at other courts that there should have to be some sort of statement up front about that. And our brief argued defended the use of the buyer agency agreement and basically explained that because of that contract, that the buyer agent should be able to collect their commission or their commission less any expenses that they were saved by the breach in the case. And the court ultimately agreed with that. At the far right of the screen is a quote. Our brief was featured heavily at oral argument and was actually quoted in the final decision. You can see that the justice sort of compared it to, as a buyer agent, you are not just sort of catching the fish, but you're teaching your client how to fish, and that education has value. The next case, Hill Junius versus UTP Realty, looked at liability for landlords. In the case, there was a recent sale of a property that had a history of problems. It was in a tough neighborhood, and shortly after a new landlord purchased the property, there was a murder at a nightclub on the property. And so the courts were kind of asking the question of what sort of liability should there be on the landlord? Should they be responsible for things that happened before they purchased the property? And related to that, basically, should the realtor be doing some sort of extensive research and making some sort of judgment, or help them make a judgment on that liability? Our brief argued that that would be problematic for real estate sort of buying and selling practices, as well as it would be highly problematic for real estate, especially in sort of tough real estate or in lower income neighborhoods, where it would hinder the ability to get loans, cost of insurance, value of property. As you can see in the picture in the middle of the screen from the quote, the court took our brief very seriously, again and again ruled in line with our filing. The next case, Town of Tingsboro versus Recco, is a case that we're actually going to be filing a brief with a couple partners tomorrow. So very timely. It deals with an issue called home equity theft that was recently declared. The law in Massachusetts was declared unconstitutional by the U.S. Supreme Court. As it stands, Massachusetts law would allow municipalities to sell your home for to relieve property tax debt. However, unlike a traditional foreclosure where the rest of your equity in your home would have to be returned to you beyond the debt, the towns in this case did not have to do that. And so there's kind of this hole right now in Massachusetts law. We're working legislatively to try to get it fixed, but in the meantime, the land court has asked for our feedback in this case. And so we've given them a few options and kind of explained our view of the world on home equity theft and what exists now following that U.S. Supreme Court decision making Massachusetts law invalid. Finally, Carroll v. Norwell Select Board. Town of Norwell had set aside some land for affordable housing uses a couple of decades ago. Over time, they took some halting steps here and there to kind of move towards developing that. Nothing ever came of it. However, a couple of years ago, when they became really serious about developing that land, some abutters had significant concerns about that and actually got something onto the town meeting to change that reservation from affordable housing to conservation land. And our brief makes the case that we should hold that land reservation for affordable housing to a very, very high standard, and we should protect affordable housing. And that case is still pending before the courts. So with that, I will turn it over to Kate to talk about professional standards.
Great, thanks, Johnny. The judicial advocacy is totally my favorite. I think you do such a great job in representing our members and consumers. So professional standards, in January, MAR expanded the state's professional standards program. We absorbed most of the local associations committees, with the exception of GBAR and NEAR, as we had added the Cape and Islands in May. In total, we've had over 100 inquiries into the professional standards process. Approximately a little more than a third were from members of the public. Those inquiries primarily focused on alleged ethical violations, focusing on property management, misrepresentation, fair housing, disclosure issues, handling of rentals, really on responsiveness, questions of procuring cause, conflicts of interest. Of those 100 plus inquiries, 27 were formally filed. 21 of those were ethics complaints, 6 were arbitration requests. One of those ethics complaints was dismissed by grievance. 15 were pushed forward to hearing. Of those arbitration requests, 1 was on hold to hearing. We have 5 for a grievance meeting that's happening on the 1st. Of those filed, 17 were by members, the rest by the public or out-of-state realtors. Sorry about that, Justin. And go to the next one. So if we look at professional standard filings for 2023 and sort of a breakdown of where they come across, I thought it was interesting to see that both May and October had the highest months of filing, thinking about our seasons or the seasonality of our business. That was interesting to note. If we go on to the next one, we really talk about how ethics proceedings are about education and vindication, really, for the aggrieved party as to the alleged allegation or violation of the code of ethics. When we look across the boards who utilize the state services, you can see they're spread out across the state. With the exception of Pioneer Valley, we haven't received a complaint yet from that area. I share this slide as a reminder that your local association is still offering ombudsman services. So if you would like to first reach out to them to have an informal conversation with you and the Realtor member, it can be a good spot to start. Oftentimes ethical issues, not always, but often are a result of miscommunication. In fact, we did successfully have one resolve through efforts of this sort of informal conversation. It seemed that the misinformation between the parties was an attorney, so put them at fault. Just a reminder that ethics panels have a wide latitude in the recommendation of their sanctions. They can be as little as a warning in a member's file to as much as a $15,000 fine or termination of membership. They usually almost always include a requirement of some education. You can go on to the next slide. So the articles of the Code of Ethics fall into three primary buckets. So we have number 1, duties to clients and customers. Those are articles 1 through 9. Then we have duties to the public, articles 10 through 14, and then duties to other realtors. So realtor to realtor, those are articles 15 through 17. Most of the allegations fall under bucket number 1. So we had 21 allegations involving articles 1 through 9. Interestingly, no complaints include those violations of articles 5, 6, or 7, which is great because those involve commingling your personal interest as a professional and that of your client. If we go on to the next one, we can talk about some of those most cited articles. So Article 1's primary focus is on protecting and promoting the interests of your own client, but this does not relieve a realtor from treating all parties honestly. And this is an issue that has been cited the most in the complaints that we have received. Part of those, if we look at the standards of practice, really focus on submitting offers and counter offers objectively, quickly as possible, continuing to do so unless instructed in writing otherwise. Recommending always that your client seeks legal advice before entering into a contract if there remains, a previous contract that you're unsure if it was terminated or not. To Catherine's point about termination of contracts, they're mutual. So if you understand your rules about escrow funds, those two require a mutual assent. So if you have a question relative to the termination of a previous agreement, you certainly should counsel your client to seek attorney advice. You're required to preserve confidential information continuing through the termination of your agency relationship. You need to manage with due regard for the safety and health of tenants and the property of those properties that you manage. Surprising to me, there were quite a few complaints that came in relative to the management of properties. So when you have realtor agents that also engage in management, you should have a thorough conversation with them about those duties. Really importantly, and I think it's come up quite a few times, is about access or using the property or permitting others to access or use the property in a way that is not what the seller has advised you to do. As a realtor, as an agent of the seller, you're required to follow their lawful instruction. I think this really comes up when we talk about Article 3 and the duty to cooperate. Cooperating with other brokers is usually in your client's best interest. And that's why this article is under that first bucket, duties to clients. Cooperating means sharing information and making the property available for the other realtor to bring their client to. Remember, cooperation does not include the duty to share commission or fees. I think this is really important when we think about what this looks like moving forward in a lot of ways. Remember that the terms of compensation, thinking back to the form that Catherine shared with you and Justin's presentation on the lawsuits, compensation should be ascertained between businesses, between brokers prior to submitting an offer on your client's behalf. If you utilize the forms like Justin had talked about, and have a buyer representation agreement, it's much easier for you to weave that request of compensation directly from buyer to seller. So if you're thinking about changing cooperative compensation from a firm offer that's out there right now, it's very important that you have that business to business discussion prior to submitting that offer. If we look at Article 11, your service must conform to the standards of practice and competence that are reasonably expected in real estate discipline. When I think about this article, I think about specializing. I recently have received quite a few phone calls on the hotline about doing commercial deals, or as Catherine mentioned, getting into rentals, saying, I don't really do rentals, but I'm taking this one over. It's fine if you have a client that wants to work with you, just make sure that you're disclosing that this is not your area of specialization. Certainly, you should be knowledgeable and have resources. You should know about the geographical location. Competence really means that you are equipped to reasonably protect the best interests of your client. So if it's outside of your scope, disclose it's outside of your scope. They most likely still want to work with you. At that time, it's really important to use your bank of resources to point them in that direction, whether it's counseling with their own attorney or a tax professional or otherwise. We think about Article 15 and 16. These are duties to other realtors. These usually come in a bundle when they're filed. It's about not knowingly or recklessly publishing or repeating something false about another real estate professional, their business, or their business practices. This importantly includes republishing something that someone else wrote. In the age of social media, well, social media has been around a long time, but the fact that it's very easy to reproduce someone else's work on your own page, be mindful not to knowingly or recklessly share misinformation about another realtor professional. And if you do find out that it's false or misleading, correct it. You have a duty under the Code of Ethics to either retract or offer a clarification once you know it's false. Do note that Article 16 really has to do with interfering with exclusive representation agreements or relationships that other realtors have with their clients. You as a realtor must take no action that's inconsistent with that. This does not mean that you can't be aggressive or innovative with your practices, make general announcements or general phone canvassing or mailers. You just need to make sure that you are focused on an entire neighborhood, an entire geographic area, profession, business club, organization. You're not specifically pinpointing one seller, for example, or one buyer when you already know because of a sign or an MLS listing that they're still under exclusive relationship with somebody else. I think the time that this comes up the most is when we think about exclusive listings that have gone into withdrawn status. It's just important that you double check your lead sources to make sure that those clients are not still under an exclusive relationship. When we think about arbitration matters, we've had 6 total arbitration requests filed. They all have been mandatory arbitration. So in order to file an arbitration request at all, there must be disputed funds of some sort, and they must arise from a business relationship. Well, in our profession, we have a lot of different business relationships. We have broker to broker, we have broker to salesperson, or broker to broker within the same office. We have a business relationship between broker and client or consumer. So you need to understand which are mandatory to arbitrate through the association and which are voluntary. Mandatory is principal to principal, 2 different offices. Also, if you are a member of a Realtor MLS, you also have signed up to be held to mandatory arbitration. A client may also invoke this against you as the Realtor member, and it would be mandatory for you, although the client would have to agree to be bound. As a side note, our agreements with you, our exclusive listing agreements and buyer-broker agreements have clauses in there that list that any disagreement would be up for arbitration through the board or AAA. Voluntary arbitration is when you're affiliated with the same firm or the realtor principal against their client, or if there's a non-member involved. We have one of the arbitration matters on hold. The parties that have agreed to talk to each other. We did also have one interstate arbitration. That's where parties to our interstate agreement, members of professional standards, get together to have a joint hearing on the matter. We've seen monies ranging from $7,550 to $15,500. They all involve questions of procuring cause. When we think about procuring cause, a lot of the calls that we get, as Catherine had mentioned, could be on this topic. We don't have a clear answer as to what firmly establishes that you're the procuring cause in a transaction. The panelists consider the entire course of events and many factors and checklists in order to make that determination. As a reminder, looking into mediation, which if you contact me with a complaint, I will continually remind the parties that mediation is a very viable option for you to help have control over the way that this situation pans out. An arbitration award 99% of the time is all or nothing. Just a fun fact, I think important, you can file proactively if you have 2 agents coming to you as the listing broker, you're holding those commission funds, you've offered cooperative compensation, you don't know who to pay, 2 people are telling you, pay me. You can ask grievance to consider and resolve those competing claims, and the parties that wish to be paid are those that pay into the arbitration. If you want to learn more and become involved, please contact me. I'm happy to talk about these issues. You can look at our website. It really is helpful with frequently asked questions. But I think more importantly, we need your expertise. If you don't already, if you're not already involved in professional standards, we could definitely use you. Your expertise is different. And as I said before, realtors are specialists in different areas, in different specifics. So the more variety we have, the better we are at offering a very fair hearing. And of course, if you're interested in attend our professional standards training with Diane Disbro at MAR on February 1st.
All right, Justin, do you want me to take this slide? Okay. So thanks, everybody. We are going to be right on time this afternoon and end at an hour. This is being recorded. So if you'd like to take segments of this and play it in an office meeting or just review a certain section, we'll provide a copy of the recording for you after today's event. And again, here is our contact information. You can email the legal hotline at legalhotline@marealtor.com or call the 800 number. Again, Catherine and Kate compile the notes from the legal hotline and publish them on our website. So if you're looking for information for a sales meeting or more in-depth coverage on a specific issue or topic, especially those that were the most frequently asked questions, you can find those on our website. All the legal resources and advocacy information that Johnny spoke about, you can find on the legal resource section on our website. And our blog is constantly being updated, and you are welcome to take any of our blog posts and share them with your friends and colleagues, anything that you think would be helpful or informative. So we are here for you. Advocacy and legal resources are frequently the #1 member benefit that our members report to us. So we're thrilled to be here to support you. And if you're experiencing something or seeing something new, different, or curious, please give us a ring. Let us know, and we'll help solve and investigate for you. With that, I hope you all have a wonderful rest of your day, and thank you for joining today. And thank you so much to our legal team, Justin, Johnny, Catherine, and Kate, and Sabrina for putting this all together.